that Mr. John McCarthy was shot dead on the 20th of April 2000 by a member or members of An Garda Síochána. This followed a lengthy siege which extended over the previous day into the afternoon of the 20th. He fired shots already, so the Garda had an armed response unit present. The final fatal encounter occurred when he emerged from the house with the shotgun. He refused to comply with instructions given to him by the Garda Síochána verbally, and he was shot. Now, naturally, as well as being a use of lethal force, there were particularly unusual features about this case in terms of the interaction between the Garda Síochána, whether the Garda Síochána had provided sufficient access to his psychiatrist, for example, whether alternative methods of dealing with the situation had been exhausted by the Garda Síochána. So it was acknowledged within the Garda Síochána that it was necessary to have a proper investigation of this. So a chief superintendent was given the task of investigating how this killing had occurred, what had happened, what lessons could be learned from it, and he reported on this to the Commissioner of An Garda Síochána. The Commissioner of An Garda Síochána passed this report to the Minister for Justice, Equality and Law Reform. The Minister passed the report, he laid the report before the Houses of the Oireachtas. The Houses of the Oireachtas referred the report to the Joint Committee on Justice, Equality, the Defence and Women's Rights. And that Joint Committee then published this report. The report made by a Garda officer to the Commissioner, a senior Garda officer to the Commissioner. The Joint Committee published this report as its own interim report. I might pause here to say that this highlighted a practice about which there's still some element of disquiet. This practice of persons outside the Houses of the Oireachtas conducting inquiries or investigations on a non-statutory basis, which then report to a minister. The report can't be published because it isn't protected by any form of statutory or constitutional privilege, and therefore persons whose good name is adversely affected by what's said in the report might possibly bring an action for defamation or other types of proceedings in relation to it. The practice has on several occasions been adopted of sending this report to the Houses of the Oireachtas and a committee of the Houses of the Oireachtas then publishing the report as its own report so that it's protected by Article 15, Section 12. And I know that there was some disquiet that in the article that I wrote about Abbeylara in 2003 that I'd actually highlighted this practice because some people in the House of the Oireachtas have been attempting to avoid any public discussion of that or debate about whether there's anything anomalous or problematic about this practice of taking other people's reports and clothing them with the privilege which attaches to a publication issued by one of the Houses of the Oireachtas. At any rate, in this case, the Joint Oireachtas Committee went beyond that and has established a subcommittee to consider the report and any submissions that were made on the report, and then to report back to the Joint Committee with its recommendations. Now, the subcommittee's report powers were subsequently enlarged to specifically include the taking of evidence, the summoning of witnesses, the requirement that documents be produced, and the making of findings as well. So findings and recommendations. There was an amendment to the terms of reference to the subcommittee which expressly authorised this, although it might be said that one of the features of the Abbeylara case was that the paper trail was very confused and incomplete in relation to in what order the steps occurred, and some of them weren't actually documented, although it was accepted that they had been undertaken, and there's quite a lot of criticism from some of the judges about the rather sloppy, slipshod nature of the way in which the committee, the subcommittee, and the committee, and the compellability committee as well, carried on its work. So the legal framework, broadly speaking, insofar as it's relevant to us, is that under the Committees of the Houses of the Oireachtas Compellability, Privileges and Immunity of Witnesses Act 1997, it was possible for a Dáil or Seanad committee, or a joint committee of the two houses, or a subcommittee of such a committee, it was possible for a committee or subcommittee to issue directions that persons should appear to testify, or that they should produce documents to the committee. And if a direction was properly issued under that Act, it was a criminal offence to fail to comply with it, or to give false evidence, obviously, to the committee or subcommittee as well. But in order to give such directions, the 1997 Act didn't give all Oireachtas committees and subcommittees the automatic power to issue such directions. In order to issue such a direction, the subcommittee needed to apply for a consent from a subcommittee appointed jointly by each Committee on Procedure and Privileges. That is, the Committee on Procedure and Privileges of the Dáil and the Committee on Procedure and Privileges of the Seanad jointly had to constitute the so-called compellability subcommittee, which would consider applications from other Oireachtas committees and subcommittees to be given the power to issue these directions. And this therefore was a requirement before these statutory powers would kick in, which would allow the subcommittee to summon the Gardaí in particular before the subcommittee to give evidence as to what happened at Abbeylara. Now, one important element of the case is that both the High Court and the Supreme Court in this case confirmed that not only compliance with the 1997 Act was subject to judicial review, so because the subcommittee was relying on an Act of the Oireachtas here, and the exercise of certain powers under the Act of the Oireachtas in question, the courts had the power to judicially review whether the powers exercised under the Act had been exercised in a lawful manner. But also, the courts were entitled to review, they were entitled to interpret and decide upon the correct application of the standing orders of the Dáil and Seanad, insofar as they were relevant and connected with the exercise of this statutory power. So that justiciability issue was one where there was very little doubt or hesitation by the High Court or the Supreme Court that the matter was justiciable. And one important reason for that was because it was affecting the rights, the reputations, livelihood and other rights potentially of persons who were not members of the Houses of the Oireachtas. So there's that element, which as we've seen in the Callaway and Moylan case more recently isn't necessarily crucial, but it was certainly emphasised by the Supreme Court and the High Court in this case. So in relation to the conduct of the inquiry, the subcommittee obtained a consent in verbal form, but then only several weeks later did it get that consent reduced to writing by the chairman of the Compellability Committee. So this is an example of the rather lax attitude of the TDs and senators who were involved in this case towards fulfilling the procedural requirements of the statutes and the standing orders. Now, the subcommittee issued directions to individual Gardaí to appear before the subcommittee and to testify. And I should also say that some of the judges treated the subcommittee as having deceived the Compellability Committee by misrepresenting its own terms of reference at the time that it applied for the consent, because the subcommittee's terms of reference were, at least as far as the judges were concerned, materially altered after the consent had been applied. Now, the subcommittee regarded itself as being capable of making a finding of fact that some named member or members of An Garda Síochána had unlawfully killed John Carthy. They regarded that as falling within the task which had been given to them to consider the report and make findings on the report and recommendations. So remember, what they started off with was a consideration of a report into the incident which had been prepared by a senior Garda officer. In the context of considering that report and making recommendations about it, they decided that inherent in that was the power to find specifically that a named individual, a named member of An Garda Síochána, had unlawfully killed Mr. Carthy. In relation to the procedures they proposed to adopt, the most salient element was that they said, yes, we would allow cross-examination of witnesses. The idea was the witnesses would appear before the subcommittee, they would be examined by the chairperson of the committee, subcommittee, and the members of the subcommittee who would ask them questions. Then, anybody who wanted to, who was present and recognised by the subcommittee, could apply for leave to cross-examine the witness. And so the subcommittee would have to decide whether to grant leave. And they also indicated that in practice, that cross-examination wouldn't happen immediately after the committee member, the subcommittee members had questioned the witness. That cross-examination would be postponed to 1 or 2 days at the end of the subcommittee's hearings. So all the cross-examination would take place at once, several days or possibly several weeks after the witnesses had given their evidence in chief. And that obviously was a point which John Rogers in particular, part of the Gardaí, challenged most vigorously. So no, this hearing didn't actually occur because the work of the subcommittee was suspended pending the opportunity for the Gardaí in question to challenge these matters that I've just mentioned in the High Court and the Supreme Court. If we move immediately to the Supreme Court's decision, which largely corresponds to what the Divisional High Court decided, the Supreme Court decided, starting from the most specific point and moving to the most general. First of all, by a 5-2 majority, the Supreme Court decided the consent was invalid because it hadn't been given in writing. It was a specific requirement of Section 3 of the 1997 Act that the consent be in writing and be signed by the chairman of the Compellability Committee, subcommittee. The majority of the Supreme Court decided, well, this consent wasn't originally given in writing, and therefore that couldn't be cured by subsequently reducing it to writing. And therefore the attempt by the subcommittee to rely on the 1997 Act was null and void. They didn't actually have the power to direct anybody to appear before them and testify to them or produce documents to them. And by a 6-1 majority, and the two dissenters here were Chief Justice Keane and Mr. Justice Murphy. By a 6-1 majority, they held the arrangements for cross-examining witnesses would, if they were put into effect in the way the subcommittee proposed, breach the right to fair procedures, the right which had been identified in the Hawley case. So to say as a general rule that if you were allowed to cross-examine a witness, you wouldn't be allowed to cross-examine the witness until several days or weeks after they've given their evidence in chief, would be to deprive cross-examination of its value to a party who is seeking to vindicate his or her rights by cross-examining a person who was accusing them of something, or at least giving evidence which was adverse to their reputation or their other rights and interests. And of course, more fundamentally, again by a 5-2 majority, the Supreme Court decided that the Oireachtas had no power to conduct an inquiry of this kind, which was liable to lead to a finding damaging to an individual's good name. So the majority of the court said, this isn't a function which is inherent in the legislative authority of a sovereign state. It's not the case that every sovereign state, in every sovereign state, the legislature necessarily enjoys the power to conduct inquiries into matters of public importance of this kind. And indeed, the judges gave specific reasons as to why TDs and senators were not suitable office holders to conduct inquiries of this kind, and why the good right to good name and perhaps the other constitutional rights of individuals would be at grave risk if such a power was recognised. And they looked at the history of the matter, the fact that the British Parliament, whereas select committees of the Westminster Parliament had at one stage attempted to conduct these inquiries, for almost a century that attempt had been given up because of the acknowledged limitations and defects of this system. I pause to say, of course, that in my 2003 article in the Irish Jurist, I pointed out that if you looked at the then other 14 member states of the European Union, in the vast majority of them, the national parliament had this power. The Supreme Court's response to that, although they did consider it to some extent, was to say, well, this power is expressly provided for in the constitution of most of these other states, which clearly indicates that it's not a power which is inherent in a national legislature, because it's necessary to spell it out, which never seemed to me to be a very persuasive or convincing argument. I should say that actually, I've always thought that Mr. Justice Keene's dissent in this case was far more persuasive on that point than the views of the majority. In terms of the declaration they made, though, there is a significant difference between the declaration which the Supreme Court gave and the declaration which the High Court had given. The High Court gave a quite wide declaration. It said the conduct of a public inquiry with the aid of the power of the state and conducted by members of the Oireachtas under the aegis of the House of the Oireachtas, and with the authority thereof, liable to result in findings of fact or expressions of opinion adverse to the good name, reputation, and or livelihoods of persons not members of such houses, is ultra vires the power of such houses. So what was ultra vires was the conduct, it seems, of any inquiry liable to result in findings of fact or expressions of opinion adverse to the good name, reputation, and or livelihoods of persons who are not members of the houses in question. So that was completely general. It wasn't limited in any way to the facts of the case or the particular context in which the issue had arisen in this case. By contrast, if you look at the Supreme Court declaration, the Supreme Court declaration was precisely that the conducting by the subcommittee of an inquiry into the fatal shooting at Abbeylara on the 29th of April 2000, sorry, it's the 29th of April, 2000, capable of leading to an adverse findings of fact and conclusions, including a finding of unlawful killing as to the personal culpability of an individual not a member of the Oireachtas, so as to impugn his or her good name, was ultra vires, in that the holding of such an inquiry was not within the inherent powers of the House of the Oireachtas. So there's an ambiguity in the phrase such an inquiry, of course, as to how much of the specification in the earlier part of the declaration is captured by that adjective such. But that was quite a deliberate change. The judges say they were deliberately narrowing the scope of the declaration as compared to the declaration which was given by the High Court. And why was that? Why did they think that the High Court's declaration was too wide? I think it's fair to say that most of the judges agreed with the broad principle which the High Court was enunciating, and they didn't really wish to call it into question by narrowing the scope of the declaration. But there were a number of nuances that certain members of the Supreme Court did want to introduce. So, for example, Ms. Justice McGuinness said the Oireachtas does have a limited power to inquire, but it can only inquire in a way that's solely and directly in aid of the functions of each house. So the Dáil and the Seanad have legislative functions. The Dáil uniquely has the function of holding the government responsible to it. So directly and solely in pursuit of those constitutional functions, it would be possible to inquire into matters. And the powers of the House of the Oireachtas should be viewed in terms of a balancing of the exercise of those functions with the constitutional rights, the right to good name and other rights of individuals, and also having regard to the principle of proportionality. Now it seems as a result of that, Ms. Justice McGuinness concluded that there was no power to make findings of culpability against individuals because she couldn't conceive of circumstances in which that would be directly and solely related to the constitutional functions, the legislative function or the accountability function of the law. Mr. Justice Murray also addressed, as he then was, also addressed this question. He said the Oireachtas can conduct inquiries of the nature which they have traditionally done, including inquiries into matters concerning the competency and efficiency in departmental administration, as well as matters such as those concerning the proper and effective implementation of policy, and to make findings accordingly. So he didn't want to call into question the ability of the Oireachtas generally to make findings of fact. And I suppose that's one of the reasons why the scope of the declaration was narrowed. One point that Ms. Justice McGuinness adverted to was it was difficult to see how the subcommittee could justify, in this case particularly, the necessity to make a finding that a particular named individual had been guilty of unlawful killing, as to how that could relate to any legitimate issue which arose in relation to how the law ought to be changed or how the practices or procedures of the Garda Síochána ought to be changed. To ascribe criminal responsibility, really, to particular named individuals couldn't really be seen to relate to any legitimate decision which members of the Oireachtas have to make in their function as legislators or otherwise. And Mr. Justice Kagan perhaps was the most specific about why the declaration had to be narrower than the declaration which the High Court had given. He said, a legitimate inquiry by a committee of the Oireachtas which was directed towards a perfectly proper legislative purpose might inevitably and unavoidably lead to implied blame being attached to an individual, or may inevitably result in a finding of fault in a management system which in some circumstances could involve an implied attachment of blame to the relevant manager. So Mr. Justice Kagan perhaps went furthest in saying that as long as there's not a specific and explicit finding of personal culpability directed to an individual, then in terms of the indirect byproduct of a committee's conclusions about more general issues of fact in relation to deficiencies in public administration or deficiencies in regulation, for instance, of an area like banking, those general conclusions may may have adverse repercussions for the good name or reputation of an individual. But in Justice Kagan's view, that wouldn't be sufficient to deprive the Oireachtas of their entitlement to engage in such an inquiry. Now, in relation to the dissents, as I've said, Chief Justice Keane dissented and said no, the Oireachtas did have an inherent power of inquiry, and nor did he think that there was any substantial or serious error, procedural error, which deprived the subcommittee of its entitlement to rely on the 1997 Act in the way the majority thought. He said, yes, it's true that a consent in writing signed by the chairman of the committee is specifically required by the statute, but that wasn't a mandatory requirement in his view in the same way the majority saw it. It was clear, there was no doubt in substance here that the Compellability Committee had considered the matter and decided to issue the consent, so the fact that it hadn't been reduced to writing for several weeks was not, in his view, fatal to the subcommittee's exercise of its powers. And he thought the only problem, therefore, was the restriction on cross-examination. He accepted that that was a violation of the Haughey principle, the principles laid down in Ray Haughey. And of course, it's notable that Miss Justice Murphy, at least one member of the Supreme Court, dissented on all points and would have reversed the decision of the High Court entirely and held in favour of the subcommittee on every issue. In relation to bias, briefly, which is an issue which sometimes arises, none of the judges said that institutional bias prevented TDs and senators conducting this kind of inquiry. So none of them said, simply because they're TDs and senators, simply because of the position they occupy in the constitutional structure, they can't carry on this kind of inquiry because of institutional bias. And in fact, the three judges who considered this matter each said that there wasn't any automatic preclusion by reason of institutional bias that would prevent TDs and senators from conducting an inquiry. But it is emphasized in several of the judgments that as a practical matter, in order to escape a finding of bias, an appearance of prejudgment, a TD or senator would have to abstain from any public statement that would give rise to a reasonable apprehension that they had prejudged the matter, that they'd already formed a conclusion, which particularly a conclusion which could be adverse to the reputation of an individual, which in practice is a difficult restriction for TDs and senators to observe. And finally, I want to say two things about a pair of subsequent cases. In Curtin and Abbeylara, which was decided about 4 years afterwards, there obviously you were dealing with the prospective removal of a judge from office by resolution of the Dáil and the Seanad. So you were dealing with an express power given to the Houses of the Oireachtas by Article 35, Section 4. And what I wanted to just say about the Curtin decision is the very strong emphasis in the Curtin decision, of course, that fair procedures had to be observed. Even though this was an express constitutional function, the members of the Dáil and the Seanad had to observe fair procedures. That's qualified, I suppose, in one way by saying that the court would accord deference to the Dáil and the Seanad in the carrying out of their constitutional function. It would give them some margin for manoeuvre, some flexibility about how they went about carrying out the function. But at the end of the day, the Supreme Court did emphasise that judicial review was available, not just in relation to the procedures that were followed, but if an irrational or capricious or arbitrary decision was taken to remove a judge from office, then that too would be open to judicial review, even if there couldn't be said to be anything procedurally questionable or procedurally flawed in the way in which it had been reached. And finally, Ahern and Mahon may be relevant to trying to clarify exactly what the Abbeylara decision requires, because you might recall in that case the High Court, Divisional High Court, decided that no tribunal could make a finding, expressly or directly at least, that a TD had lied to the Dáil, or even that a TD had made a factually incorrect statement to the Dáil. The privilege, which are the non-amenability, which is given to a TD or a senator under Article 15, Section 13, in respect of utterances they make in the Dáil, meant that a tribunal could not inquire, couldn't look behind the statement the TD had made to the Dáil and specifically make a finding that the TD had set out to deceive the Dáil, or even a finding that what the TD had said to the Dáil was inaccurate. The tribunal has to pass over that issue in silence. It can't allow any questions to be put to the TD if the TD is giving evidence. It can't reach any specific conclusions in relation to that matter in its report. But rather paradoxically or ironically, the court also said, of course, the tribunal is free to make findings of fact from which any reader of the report might infer for himself or herself that the TD made a false statement to Dáil Éireann, and that in doing so, he or she deliberately deceived Dáil Éireann, as, for example, in relation to the state of his or her personal finances. So here Bertie Ahern had made certain statements to the Dáil about his personal finances. It was held, you cannot ask Bertie Ahern questions about whether that statement was truthful, whether it was accurate, or whether he knew it was inaccurate at the time he made it. But at the same time, that doesn't preclude the tribunal from making findings about the actual state of his personal finances, which would lead a reasonable person to conclude that he must have been lying to the Dáil, or at least forgetful when he made the statements in question to Dáil. So those were those are the comments I wanted to make about Abbeylara. It is fairly clear from Abbeylara, I wouldn't want to create a false impression, it is fairly clear from Abbeylara that the majority of the judges considered that a committee of TDs and senators never really could have a legitimate function, a legitimate power to make findings of fact which imputed culpability to named or clearly identifiable individuals. But there are some nuances or qualifications to that in relation to how far a committee looking into matters that are of legitimate, general issues that are of legitimate public interest can reach conclusions from which a reasonable person would infer some degree of personal blame or fault. Probably not culpable, probably not criminal responsibility, but some kind of other culpability or fault which might be inferred in these circumstances.